Good morning, everyone. We are just waiting for attendance to join. So just give us 1 minute, please. Okay, so good morning, everyone. So by way of introduction, for those who do not know me, I'm Ahmad Saleh. I'm partner and I head innovation and patents at Al-Tamimi & Company law firm. For those who do not know Al-Tamimi & Company, so Al-Tamimi & Company is a law firm. We're the largest law firm in the MENA region with 16 offices in 9 countries. We are 82 partners today and with over than 350 lawyers across the region. We are a multi-practice law firm, and innovation and patents is one of our practices and one of our star practices in Al-Tamimi & Company. And we are all stars. So we're discussing this morning the new industrial property law, which has recently been issued in November 2020 and entered into force recently in November 2020. And this law came within the largest legal reform in the history of the United Arab Emirates, with more than 50 laws which have been either updated or introduced to the legal regime in the United Arab Emirates. So the new industrial property law addresses protection of innovations in the United Arab Emirates, which include the mainland and free zones. We're going to go through the industrial property law, the main stations or the main aspects of the new industrial property law. We will have a general overview of the various legal vehicles within the new industrial property law. And then we will discuss how this impacts on innovation owners in the United Arab Emirates. So the new industrial property law addresses different legal rights, which are all concerned about the protection of innovation, starting by patents for the protection of inventions, utility models, which also addresses the protection of inventions, but it's a kind of a simplified patent, and we will discuss it a little bit more in detail as we go through the presentation. Trade secrets, which protects confidential information with a certain value to the company. Industrial designs, another legal right which protects the visual features of products and articles. And finally, the layout designs of integrated circuits, which protects the layout designs of semiconductors. So these are the main 5 rights which are comprised within the new industrial property law. First, let's have a look on patents. What does the industrial property law says about patents? Patents are there to protect inventions, and inventions, well, and this is not a new topic. It has been there in the former industrial property law. The new law comes to introduce some new aspects, which we will discuss, and I'll point these to you as we go through the presentation, and to give certain also details on certain definitions of certain criteria or other aspects in relation to patents, which is great as well. So patents are there to protect inventions. Invention is defined in the industrial property law as a new innovative product or process, which and it has to meet, of course, certain patentability conditions and the criteria for that invention to be able to secure patent protection. And the monopoly, which is provided under the law, is 20 years. And this is consistent as well with the international standards and with the protection coverage, which was provided under the older law as well. So protection is 20 years from the filing date. And what the law has introduced as something which is new during the registration process of patents, because a patent, in order to secure protection for a patent, one has to file a patent application and to follow the protection procedure and registration procedure in front of the patent office until issuance of a registration certificate for that patent. So patents, in order to secure protection for these, should be registered in front of the patent office, and there's a process to do that, from filing a patent application, going through the examination procedures and route in front of the patent office until the issuance of a registration certificate. Now, for those who've been in the country before, and they know, and they've applied or for a patent before in front of the UAE patent office, they know that this examination process or the pendency period before patent application gets examined was pretty long. We're talking about 2 to 4 years. Now, fortunately, under this new regime, this pendency period is expected to be reduced, and we'll talk about this in a minute as well. So once this patent is granted, it provides protection within the United Arab Emirates boundaries, and the new law came to specify as well that this includes not only the mainland, but the free zones as well. So to provide more clarity about the territorial protection of patents in the United Arab Emirates. Now, who should apply for a patent is the patent applicant, and the patent applicant or the owner of the patent is the person or entity which is entitled to file for a patent application. And the patent applicant can be, of course, a company or can be an individual. Now, for inventors, of course, are mentioned on the patent application when it's filed, and once it's granted, their names appear on the patent registration certificate, whether the inventors are the patent owners, the patent applicants, or not. Now, what the new law came and specified, something which is new with respect to the old law is that the inventors can choose not to put their names or not to mention their names as inventors on the patent application. So this is quite new. But still, inventors, they are the ones who decide. I mean, no one can force an inventor not to mention their name on the patent application. Why? Because this is related to the moral rights of inventors, which until the introduction of this new law, moral rights related to inventors were not possible to be waived even by the inventors themselves. So the inventor could not choose to waive his moral rights in the old law. Now, the new law came to say inventors can choose not to mention their names on the patent, which is a kind of, we see it as a waiver to the moral rights of inventors, which they can choose to adopt. The new law came to introduce urgent patent applications, and this is quite new as well. And the law did not specify what urgent means, but it depends on the circumstances. So in case there is an urgent patent application, the patent office can expedite the examination process for this. So they've introduced a kind of a fast track for urgent patent applications. Now, from our experience, of course, in other jurisdictions, this is something which is available in a number of countries. And of course, there isn't one specific or situation of urgency, but one of the scenarios is if there is imminent, for example, infringement taking place, it's used as one of these arguments to ask the patent office to expedite the process of examining and issuing the patent, because there is an infringement taking place, and this infringement might have an irreparable harm, for example, to the patent owner, or even stronger to the public in general. So this is one of the scenarios as an example. However, urgency is not limited to one or two scenarios, and is based on arguments which are submitted, and it will depend at the end of the day at the discretion of the patent office to decide whether a specific situation is urgent or it is not urgent. So as for the patentability criteria, as mentioned, a patent in order to be issued, it needs to be examined by the patent office, and it needs to meet the patentability conditions specified under the law. The first one is a worldwide novelty, and this has not changed. It has to involve an inventive step, in the meaning that it should not be obvious for a person skilled in the art. And this did not change, but what is inventive, what is obvious, what's not obvious, this is, of course, assessed by the patent office on a case-by-case basis. And we hope, as you know, the precedence regime in the UAE develops, that we have more specific tests on specific types of inventions, for example, computer implemented inventions or others. So we hope some examination guidelines or some specific tests are developed in certain areas which are a bit less clear to assess, in order to provide more predictability to patent applicants as well. Industrial applicability is another, of course, condition of patentability, and the new law came to specify that industrial applicability of an invention needs to be met, and meaning that it has to be able of being manufactured or used in any sector. So manufactured or used in any sector, which is extremely wide. So manufactured refers to something which is maybe physical, mechanical inventions, transformation. So this is in line as well with many jurisdictions which require kind of physical actions or tangible results resulting from an invention to be patentable. But also the definition says or used in any sector, or used in any sector, which is pretty wide. So for example, a computer implemented invention, or which is implemented by a processing unit, executed by a processing unit or a computer, is something which is used, and in any industry, it can be, for example, ICT or others. So, which is good. I believe that, you know, the definition is wide enough to open the door to leave this criteria flexible and not being used by the patent office during examination to over restrict the eligibility of certain inventions, which I find it positive. The other criteria is the unity of the invention. Of course, this is one of the conditions which relate to having a single invention covered in one patent application. So you cannot have more than one invention covered by a same patent application. And this is a little bit in line with the international practice as well. And why is that? When you file for a patent application, you pay examination fees. So you're buying one ticket to go to examine an invention. The patent office doesn't want to examine several inventions with only one examination fees. A little bit the rationale behind the thinking of the unity of invention. However, the new law here came and introduced the availability of divisional patent applications. So in case one patent application comprises or covers more than one inventive concept, so more than one inventions, you can either the patent office by them requesting you, or you can decide to divide it and to file divisional patent applications such that each divisional patent application covers a single inventive concept. Divisional applications are not something new in the United Arab Emirates. So they were even covered under the older regime. However, it's the first time that the patent law comes and addresses and speaks about divisional applications in an express manner, which is a very positive step as well. The invention, of course, need to comply with public moral and Sharia, and has to be an eligible subject matter. And I'll come to this in a minute to explain what is eligible subject matter. So another thing which is new in the law, and which we find very positive, is the introduction of a grace period, of a 12-month grace period for patent applications, giving the possibility to file patent applications even after disclosure of the invention by the inventors within a 12-month window period. So coming back to the worldwide novelty, an invention needs to be novel worldwide for the patent applicant to be able to file and secure patent protection for that invention. And novelty requires that no one has disclosed the invention prior to filing the patent application, whether we're speaking about the inventor, the patent owner, or any third party. And this is so this criteria was under the older regime. So what the new regime came, giving an exception for if the invention is disclosed by the inventors themselves within 12-month period prior to filing the application, that's not considered to be a novelty destroying action. So, and this is in line with the practice of some countries, such as the United States of America and Canada, which adopt a similar practice of 12-month grace period post-disclosure made by inventors. As for the examination of patent applications, so patents need to be examined substantially as to these criteria by the patent office to make sure that it is eligible for patent protection. So normally the patent office examines the patent application, and under the old regime, the pendency period before that examination takes place was a bit long. And to be completely transparent, this was concerning from the innovation owner's perspective, as 2 to 4 years before examining a patent application was deemed to be too long, and particularly speaking in our era of speed, where inventions evolve and the innovation area in general evolve and advance at a very high speed. So it was much needed for the patent regime to reduce this examination or pendency period in order to provide patent owners the possibility of quickly protecting their inventions within a short lapse of time, to be able to enforce their rights quickly also on the market before that these inventions become obsolete as well. So this is a very positive step. It's not in the law, though, that the examination period is reduced to 6 months. This has to be provided in the executive regulations, which have not been issued yet, and we're waiting for these. However, the expectation is that these executive regulations provide for that reduced examination time period, and we're optimistic that it will be the case. Otherwise, we understand that in practice, the patent office will take measures in order to reduce the examination period to 6 months. The fast track, the introduction of a fast track for urgent applications is another notable thing as well, which we discussed it. And the mention of divisional applications as well came to give more clarity and predictability to patent owners about these vehicles, which provide great strategic vehicles which are used by patent attorneys in different scenarios and in different ways in order to help innovation owners more strategically secure the protection of their inventions. I will not dive into detail about these or the procedures of doing these or the different scenarios where it's beneficial to do this. This is not the subject of this webinar to go into the technical or procedural details about these. However, we'll be happy to answer any questions on a one-to-one basis if this is of interest to you. Utility models is another form of IP rights, and it's kind of, you can look at it as a simplified patent. So it has to be novel, and it relates to inventions which need to be novel and need to be industrially applicable as well. And normally these relate to products, which are novel and they can be manufactured or used in any sector. What distinguishes utility models from patents is more about the inventive step or the obviousness. For patents, an invention needs to be inventive in the sense it shouldn't be obvious for a technical person to come to that invention. It shouldn't be trivial. It shouldn't be something which is extremely trivial to come to without efforts or without experiments or without, a failure, trial and failure. For utility models, this inventiveness condition is not is there, but not up to the threshold required for patents. So this is the advantage of utility model, where an invention does not qualify to go for a patent. There is an interest, of course, to go to for protection of utility model and seek, rather than 20 years protection, this vehicle will provide you with a 10 years protection window, which is great as well, honestly, in our days with the advancement of technologies and innovations, and 10 years window is sufficient for most inventions, especially when we speak in the high-tech sector. So, which is very positive, and it's possible also to switch from patent application to a utility model application through the process. So if a patent application is filed, it will be possible to convert it to a utility model application in case the invention doesn't meet the inventive step criteria required for patent registration, which is also positive and provide with some also options on strategical, maneuvers, how to maneuver between both, of course, in the interest of innovation owners. Utility models need registration, as the case for patents as well, and provide a protection in the United Arab Emirates, including the free zones. Speaking about eligible and non-eligible subject matter, that's something that I discussed in the previous slides, and I mentioned that I'll come to that in a minute. So even if an invention is, there is a new invention and it meets the criteria, but it also has to be within these categories which are allowed to be granted as patents. It shouldn't be a non-eligible subject matter. And there are a couple of categories of non-eligible subject matter for public policy reasons and different reasons behind them. For example, if an invention is harmful for the health of humans, this shouldn't be granted a patent, and it shouldn't. It will be excluded or rejected by the patent office as being non-eligible subject matter. Natural materials which are discovered are not considered inventions protectable by patents. Why? Because they are discoveries, considered to be discoveries or natural, coming from the nature. So it's not the creation of a human mind, but it's a discovery. However, the process of purifying these, because most of these natural materials which come need to be isolated, need to be purified. These methods of isolation and purification can be patentable. And there's a big extension of these to the genomic related inventions as well. I will not go in details in this, but this is a very specific area in healthcare, which is very important for the UAE today. Methods of treatments and diagnostic methods are non-patentable subject matter. This was in the old law. Natural materials, by the way, it's the first time it's expressed as it is today in the new law. It wasn't there in the old law. Scientific theories, computer programs are not patentable subject matter. When we speak about computer programs, we're speaking about, that medium is not protectable by a patent. However, the process underlying computer software can be patent protected, of course, and there are ways to do that. It's related to computer implemented inventions, the way of processing the data, the system or the device conducting or carrying out the computer implemented process is something that is patentable subject matter as well. When we speak about computer program, meaning if you get this CD of that, let's say the example of Microsoft, Office, you cannot have this CD patented and someone copying it. It is considered patent infringement. No, this is copyright infringement if you copy a CD with a computer program. However, if you go and protect, you can always go and protect the invention underlying the software. And this is, a very specific topic of patent law, a very thorough one, which is not the subject of this webinar as well. However, I'll be happy to answer any one-to-one questions, and we do provide seminars from time to time on different on these topics. Animal and plant varieties are not subject to patent protection. These are provided separately in the plant variety protection law, and plant varieties can be protected, however, not under the industrial property law, through a different regime and vehicle, which is the plant variety protection. Schemes and rules, business methods and concepts and games are not patentable subject matter. The new law, as much as the old law, speaks about ownership of invention in context of employee-employer. This has not changed. This has not changed. The wording has changed in a certain way, but still the new law provides that for the three scenarios, if the invention is made within the scope of employment of the employee, so he's hired and expected to invent, and his contract provides for his duties to work on R&D and to come with inventions. He comes to an invention, this belongs to the employer. So you need to make sure that his duties are well mentioned in the employment contract to make sure you don't have, surprises afterwards, and you don't, have issues in terms of evidence whether these were within the duties or outside the duties. The second scenario is inventions made outside the scope of employment of the employee, however, still related to the business of the employer, and the invention was made using the resources of the employer. In this case, there is a specific scheme which has to be followed. So the inventor needs, or the employee needs, to disclose the invention to the employer, giving him that chance to claim ownership and acquire this invention within a certain period of time, 3 months. He has to give a report on that. The employer will look at it. If they have interest, they'll claim that they wish to have this invention, and then it will belong to the employer. However, the employee will have the right to certain compensation. The third scenario is where an invention comes outside the scope of employment of the employee. It's not related to the business of the employer, and the inventor did not use the business, the resources of the employer to come to the invention. In this case, it belongs to the employee. Just to mention a small bracket here, the only law in the UAE which differs a little bit about this is the DIFC law. So there's a small, some variation with respect to the DIFC law, specifically speaking about scenario number 2. which in case an invention the employer is located in the DIFC and the employee came to the invention related to the business of the employer using his resources, that law provides that the invention should be owned by the employer from day one. From day one, however, the employee will still have the right for compensation. Industrial designs have been under the old law and they're still here. The only difference which I will mention is the monopoly or the protection period has increased from 10 years to 20 years. And of course, the introduction of a 12-month grace period post-publication made by the inventor. This also applies to industrial designs. So these are the main differences with respect to the older law, but industrial designs have been there. They protect the visual features of a product or an article. They require registration. Normally, they are faster than patents to be granted because they are not normally examined substantially and they are much easier than patents or than inventions to assess as to the protection criteria, if they are met or not met. So even when these industrial designs are examined as to the substance, normally it's not that, it's not sophisticated as much as patent. That's why they take less time to examine and to issue. Trade secrets is another IP right, which is provided under the industrial property law. These are very important, extremely important today, particularly with the advancement and the rise of the high-tech sector and with the software industry, which is today, we find it in many, many sectors. So in fintech, it's there. In health tech, it's there in many sectors. So where you find codes and softwares, trade secret is very relevant to these as well. Patents are also very relevant to them to protect the computer implemented inventions related to these, which provide a very wide scope of protection. Of course, industrial designs will still be relevant to protect the visual features of any products, such as, for example, payment cards or whatever, but trade secrets are very relevant and important for software. Keep this in mind. So what trade secrets protect? They protect secret information of companies, and they have these secret information need to meet certain conditions for that information to be considered as a trade secret and to be protected. I'll come to this in a minute about the conditions. Registration for trade secret is not required. Registration in the meaning of supplying or submitting an application to the patent office or another authority is not required. However, it's important to keep in records evidence about this information, of course, and its creation. The new law comes to expressly mention certain obligations about on the trade secret holder. So if the company entrusts holding this confidential information to one employee or executive, that person has a lot of obligations of keeping this information confidential and secret. And in case of leakage, the law comes to put the burden of proof on that person to prove that he did not leak that information. And this is a big shift in the law when you shift the burden of evidence from the plaintiff to the defendant. So here, the company, if decides to sue that employee for leakage of confidential information, it's not they'll have to, of course, prove that there was a leakage of confidential information and that person was the trade secret holder. However, it's now on the trade secret holder to come and prove that he did not leak that information. So this burden is on him to prove, to defend himself and prove he didn't leak that information and that he took all the measure and the to keep that information confidential, and it was confidentially kept by him, and the leakage didn't come through means, illicit means or negligence done by him. That's very important as well, and leverages the legal position of companies as well, giving a boost to innovation owners. And as we'll discuss later in the next section. Clinical trials, information which are confidential information submitted to a governmental authority, and here the law refers to that. And what we understand, one of the main applications of that, of course, are the clinical trials data which are submitted by pharma companies to the Ministry of Health or to the authorities which are responsible of marketing approvals of pharma products. So this information is considered to be confidential, even if submitted to the governmental entity, and the governmental entity had the duty to keep it confidential for a 5 years period. Now, the only exception which is provided on that, and this is also new in the law, is the exception that the government can use this information in case of state emergency. And this is specifically addressing the situation of the pandemic and, the big, dilemma around opening patents for generic companies to be able to reproduce vaccine, the vaccine patents, and to be able to manufacture and these vaccines. So this was a big topic, has gained a lot of attention from international players. Many countries were involved, including India, South Africa, and United States and Europe, of course, which host most of these, pharma originator companies, which were on the other side. So, but the UAE came to provide this exception in case of state emergency. The government can, shortcut, this protection provided to the innovation owners. So, about the conditions for trade secret protection, what is considered to be secret? Information which is not known to the public, which has commercial value because it is secret. And the company needs to take reasonable steps to keep it secret. And they have to prove that they consider it secret by proving the measures they've taken. For example, having the employment agreement have these confidentiality clauses, having specific confidentiality agreements for whoever has access to this information. These steps need to be taken by the companies to prove that they've considered this information as confidential and it remained confidential, and they took the measures for that to be confidential. That's very important to be proactive in taking these measures, not to compromise these trade secret rights. For example, developers develop source code, or employees develop a source code inside a company. It's important to have them sign these confidentiality agreements about the code, that this source code is considered confidential and proprietary to the company, and any leakage of this code outside or to any party without the authorization of the company can cause irreparable harm to the company. And so this is important for that source code to be really considered as a trade secret, and then any leakage of that by the employee who have signed that agreement will be considered as an infringement to trade secrets. So the trade secret section as well addresses certain fair commercial practices and some unfair commercial practices, which if they are carried out or done, they will have legal consequences on the person who breached these rights, and which can face severe civil and criminal any liabilities. So what is fair? Acquiring from public sources the information. So if this is done independently from a public source, that's fair. So it's not a breach of the trade secret. If it's discovered through independent efforts by another party, if it's discovered during a scientific research independently, or if it's already in the public domain, okay, that's fair to have this information and, you know, to use this information and without being liable for any trade secret infringement. Because the information was not obtained from the company, it was obtained independently. But what is unfair is to go and bribe employees, give them money to acquire this information, or to incite these employees for any reason to leak this information to them or to any third party, or to acquire this information from the company using fraudulent and illicit means such as theft or espionage. This is, of course, it's illegal. What is also not accepted, disclosing the information if by the holder of this confidential information in a breach of contractual duties such as employment or other contractual arrangement. If it's an independent developer, for example, with confidentiality clauses, they can't disclose this information. If they do, it's a breach. So, and use of this, so it's not only the person who has disclosed, but the person who has acquired and has used this information, knowing that this information has been obtained by the breach of trade secret law. Okay, so this is an obligation. The consequences are not only on the person who leaked, but the person who acquired and who used that information in bad faith, knowing that this information was leaked illegally. It wasn't been obtained by the authorization of the holder. It's illegal information. So what are the infringement remedies, monetary remedy for the different rights in general? I'm speaking patents, designs, trade secrets, monetary damages, precautionary seizure orders, confiscation, destruction of infringing articles, and imprisonment and fines. So what is the implication of all of that to the innovation owners? Of course, the new industrial property law comes in a very important period where the country is again reaffirming their leading position in innovation worldwide, and leading position in innovation worldwide. And today, I'm sure that the UAE is considered one of the most innovative countries in the world. And I believe the ecosystem is there supporting, and the country and the authorities came to provide a strong IP regime, the industrial property law, to address the protection and enforce of innovation and the enforcement of the related IP rights. So that's a very strong message. It provides a very safe environment to innovation owners to come and work inside the country, to develop innovations inside the country, and to feel that their rights are secured. So this is one, and this is providing a comprehensive range of IP rights, and from patents to designs to trade secrets, to integrated circuits, which are not yet, by the way, the integrated circuits are not yet the registrar at the patent office has not yet been created. We hope it depends on how this industry moves, the semiconductor industry in the UAE. But we hope that if this is an industry where it will an industry which will grow, and with semiconductor companies coming here and manufacturing chips here, the law would provide for that grounds for the patent office to create that register and provide for means to protect these layout designs. The IPR system is more accessible than ever. We're expecting reduction in costs. It's not there yet. This is expected to be in the executive regulations, which are not issued, but we're expecting reduction in cost for certain types of applicants, such as entrepreneurs and startups, maybe universities, and the reduction of time frame for examination to 6 months, which would be really great. And of course, the introduction of a 12-month grace period provides more accessibility to patent protection for, especially to universities, which, where they have publications, they're making publications, they have 12 months after these publications made by the inventors to protect their rights in the UAE. The new law provides more clarity on the legal position, which enhances predictability during enforcement. It's much more detailed than the previous law, with different scenarios and provided for and provides more details about the application of certain aspects, which is very important in law, very important to provide predictability to innovation owner, what happens in these specific scenarios, and for the courts as well. When we go in front of the courts to enforce the IP rights, also it provides predictability on what kind of outcome one may expect, and can give a better guidance to the courts as well on the interference for the enforcement of rights. The company's rights we feel are leveraged with more detailed obligations on employees, okay? And this is, we've seen it in the trade secret law. There's a lot of obligations put on employees and the other rights as well. So, and that's a little bit provides companies with more comfort of developing innovation within their organization, where employees have more detailed obligations on how they should deal with this, these different innovations, including keeping secrecy and so on. And we believe that will provide incentives for companies to feel more comfortable bringing their R&D teams in the United Arab Emirates and developing further innovations. The government now, different provisions have been provided in the law to provide the government with the flexibility of shortcutting the IP rights for public order reasons, such as emergency health reasons, for example, which we find pretty fair. So it's a good balance between the patent owner rights and the public rights in general. And finally, what is our recommendations is for innovation owners to really be proactive in taking measures to ensure IPR protection, whether in taking measures to keep their R&D confidential, taking the measures to have to put agreements in place internally and externally with people involved in the development of innovations, taking measures and putting a process in place for monitoring any disclosure, and taking measures to file for patent applications, for industrial designs applications, and even for small innovations like which can be protected using utility models, for example. So these measures need to be taken by these companies in a proactive way in order to ensure that they don't, they don't get to a situation where there is a breach, but they haven't taken the measures which are required under the law to be able to secure their IP rights in due time and in due time. So this is our message to patent, to innovation owners. If you want to take one takeaway from this presentation, is this takeaway. So this brings us to the end of the webinar, and I think we're on time, but we have still a couple of minutes to take questions, if any, 2 or 3 minutes. And in case that you still have questions and we don't have the time to take them during the webinar, my contact information appear on the screen, and please feel free to drop me an email, and I'll be happy to have to respond to you, or to have a chat or a call with you to answer your queries. Thank you very much for your attendance and your attention, and I hope you found this webinar useful. And please rest tuned. We will be providing a series of publications and webinars and interviews with key individuals and companies in the innovation R&D and innovation sphere in the upcoming period and throughout the year, and all around various topics in innovation and patents. So let me go to the chat room. Thank you very much for the nice compliments in the chat room. I'm trying still to find a question, and it's all compliment. Thank you very much. I feel flattered. The question is with respect to the waiver of moral right. Is it only in relation to choosing to hide their name? The only mention with respect to, in this respect, is the possibility for the inventor to choose not to mention his name. There is no mention of a general possibility of waiving the moral rights. So, however, we know that the right to be mentioned as an inventor on a patent application, this is a dimension or an attribute of the moral rights related to the inventor, and the possibility provided under the law for the inventor to hide it. This is in a way a waiver or a limited, to that specific attribute of moral right. When do we expect the executive regulations? We are following up very closely, and it's expected to be shortly. What does shortly means? It can be, we've been waiting for this since November 2020. We're expecting this before 2022. I believe it will not take more than any couple of weeks to be issued, and we will issue a client alert once the executive regulations are issued. Okay. I think I have a message that the webinar time has finished. So I'm obliged to end the webinar now. However, there are still questions there. I invite you, if your question hasn't been answered, please feel free to send me a message, an email, and I'll be happy to respond to you on a one-by-one basis, on a complimentary basis as well. Thank you very much for your time, and I wish you a wonderful day.